Hello everyone, this is Anubrati Debnath, a trainee under LEXIS and Company for the month of July. So as you have already watched the title below, now let's get into it. It's the top news in the month of July that the sedition law, colonial, was why don't you drop it? Its Supreme Court asks the center. So the three-judge bench headed by the Chief Justice likened the Section 124A of the IPC on sedition to saw used to cut a forest instead of a piece of wood. So New Delhi says, now the Delhi court says that describing the British era sedition law as a colonial, the Supreme Court today questioned whether the law was still necessary after 75 years of independence. The law is a serious threat to the functioning resources, institutions of and holds enormous power for misuse, with no accountability for executive. The court said, comparing it to a saw in the hands of an overzealous carpenter. The sedition law is a colonial law. Do we still need the law in our country after the 75 years of independence? Chief Justice N.V. Ramana questioned. The court asked why the government, while taking a number of dated laws of the statute book, is not looking into the law. The government's top lawyer, Attorney General K.K. Venugopal, argued that the law should be retained with guidelines. A three-judge bench headed by the Chief Justice likened Section 124A of the Indian Penal Code on sedition a saw used to cut a forest instead of a piece of wood. There is enormous misuse. The use of sedition is likely giving a saw to the carpenter to cut a piece of wood, and he uses it to cut the entire forest itself. That is the effect of this law, the court said. If a police officer wants to fix anybody in a village for something, he can use Section 124A. People are scared. So the court said it would examine the validity of sedition law and asked the center to respond to a former army officer petitions that says the law causes a thrilling chill effect on speech and is unreasonable restrictions on free expression. The dispute is a colonial law. The very same law was used by the British to silence Mahatma Gandhi and to suppress the freedom movement. Is the law still necessary in the statute book in this country after 75 years of independence? The court said several petitions having challenged the seditions after law and all will be heard together. Our concern is misuse of the law and no accountability of the executive, the Chief Justice told Attorney General Venugopal. We are not blaming any state or government, but look at how Section 66A of the IT Act is continuing to be used. How many unfortunate people have suffered and there is no accountability for it. He also said there was minimal conviction or very low rate of convictions in the history of the sedition law. The Attorney General said the law need not be struck down and only guidelines could be set out so that it met its legal purpose. The Chief Justice replied, if one party does not want to hear the voice of other party, they may use the law and implicate the others, and it is a serious question to individuals. Now, Solicitor General Tushar Mehta told the court, we will file only our reply and that would lessen the burden of the court. The petitioner, Major General retired S.G. Vombatkara, argues that the sedition law is wholly constitutional and should be unequivocally and unambiguously struck down. The bench of the Chief Justice Ramana A.S. Bompana and Rishikesh Roy heard the petition that also says the law criminalizes expression based on unconstitutionally vague definitions of disaffection towards the government. The petition says there is need to take into account the march of the times and the development of the law before dealing with Section 124A. The Chief Justice said the petitioner has almost sacrificed his life to the country, so it is not motivated petition. Major General Vombatkara said the court arguing to take up his petition was heartening to those who value democratic dissent and fundamental rights. Sedition is a legal relic from the times of colonial rule. It has been removed from the British Statute book and deserves to be struck down for a republic, he said. Earlier, separate bench of the Supreme Court had asked the centre to respond to a petition by two journalists challenging the sedition law. The journalist Kishore Chandra Wakhemcha from Manipur and Kanhaiya Lal Shukla from Chhattisgarh said the law violates the freedom of speech and expression. Sedition charges has controversially been brought against activists and politician journalists in recent years. In March, the Supreme Court has said in different cases that expressing views that were dissenting and different from government opinion cannot be termed sedition. Some prominent sedition cases involve Lakshvadi filmmaker Ashia Sultana, climate activist Disha Ravi and journalist Siddiq Kapan, who has been in a UP jail for months without trial. Now, hope you like this video. This was very current and hope it was short for you. Thank you.